Hello, everyone. In this segment of the Continuous Disclosure 101 series, we will discuss issuer requirements to file certificates under National Instrument 52109, Certification of Disclosure in Issuers' Annual and Interim Filings. As a general reminder, the videos of this series are intended to be an introduction to each topic and are focused only on the requirements under Alberta securities legislation. We remind issuers that the securities exchange that they are listed on may have their own policies and rules regarding the timely disclosure of material information, and we encourage issuers to seek legal advice with respect to their specific circumstances. In addition, the views expressed in this presentation are those of the presenters and may not represent those of the ASC, other securities regulators in Canada, or staff. In this presentation, we'll address the purpose of certificates and who is required to sign them, the different forms and when they are applicable, non-venture issuer requirements regarding disclosure controls and procedures, or DC&P, and internal controls over financial reporting, or ICFR, management discussion and analysis, or MD&A, disclosure requirements, exceptions and exemptions to filing certificates, how to date your certificates and when to file them, and common issues we see with the certificates. The purpose of certificates is generally to improve the quality, reliability, and transparency of an issuer's filings, allowing investors to make more informed decisions. The certificate sets out in a prescribed form that, among other things, the individual signing it confirms that they have reviewed the issuer's applicable filings. To their knowledge, having exercised reasonable diligence, the filings don't contain any misrepresentations, and related financial information and financial statements are presented fairly. It should be noted that the fair presentation of financial information is not qualified in the certificates by the phrase "in accordance with generally accepted accounting principles," or GAAP. Certification is intended to provide assurance that the financial information disclosed in the annual or interim filings, viewed in its entirety, provides a materially accurate and complete picture that may be broader than the financial reporting under the issuer's GAAP. If the certifying officers believe that an issuer's financial statements do not fairly present its financial condition, they should cause the issuer to provide additional disclosure in the MD&A. Part 4 of the Companion Policy to National Instrument 52109 provides additional information regarding fair presentation of financial information. Lastly, separate certificates are required to be signed by each of a reporting issuer's Chief Executive Officer, or CEO, and Chief Financial Officer, or CFO, or the individuals performing these functions. If the same person performs the CEO and CFO roles for an issuer, separate certificates must be provided by that individual for each role, or the individual may provide one certificate in the capacity of both the CEO and CFO and file the certificate twice, once in each filing category. When a reporting issuer files its annual and interim financial statements, MD&A, and annual information form, or AIF, if required, they must also file the correct certification of disclosure. It is important to note that there are specified forms for annual and interim filings, and that non-venture and venture issuers generally file different certificates. Issuers should file certificates in the prescribed form outlined in National Instrument 52109 and must not modify the wording. Non-venture issuers will file Form 52109F1 with respect to their annual filings and Form 52109F2 with respect to their interim filings. These prescribed forms include, among other items, representations by the issuer's certifying officers regarding DC&P and ICFR. A non-venture issuer's responsibility regarding these matters is outlined in the certificates and Part 3 of the instrument and include required disclosures in the issuer's MD&A. I will address these requirements in more detail in a moment. Venture issuers will generally file Venture Issuer Basic Certificates in Form 52109FB1 with respect to their annual filings, and Form 52109FB2 with respect to their interim filings. These certificates do not include representations about DC&P or ICFR. Accordingly, venture issuer certificates include a note to reader that states this fact and describes the associated risks. Venture issuers should ensure that this note to reader is included at the bottom of their filed certificate. Venture issuers may file annual and interim certificates in Form 52109 F1 and F2 respectively. However, if they choose to file these certificates, they must comply with the requirements set out in the certificates and Part 3 of the instrument regarding DC&P and ICFR. The definitions for ICFR and DC&P are found in National Instrument 52109. Generally, ICFR refers to the processes designed to provide reasonable assurance over the reliability of financial reporting and the preparation of financial statements for external purposes in accordance with the issuer's GAAP. DC&P is broader and pertains to the processes designed to provide reasonable assurance over the reliability of all information required to be reported by an issuer in accordance with securities legislation. Pursuant to National Instrument 52109 and Form 52109 F1, non-venture issuers must establish and maintain DC&P and ICFR. The main purpose of DC&P and ICFR is to provide a high level of assurance that the disclosure made by an issuer is reliable. As such, the certificates include representations that the issuer's certifying officers designed these processes accordingly. Issuers should therefore take particular care in designing DC&P and ICFR. Part 6 of the Companion Policy provides guidance regarding the controls, policies, and procedures that should be included in devising these processes. It should be noted that risk of fraud must be explicitly considered in the design of DC&P and ICFR. Issuers should also consider how design will be impacted by any long-term investments they hold and be aware that they are required to use a control framework to design ICFR. As outlined in the annual certificate, certifying officers are also required to evaluate the effectiveness of DC&P and ICFR. A variety of tools can be used to assess effectiveness, and the Companion Policy provides guidance on evaluating an issuer's processes. If weaknesses in ICFR or DC&P are identified, issuers should review Parts 9 and 10 of the Companion Policy to determine if they are material or significant. As mentioned previously, non-venture issuers must include certain disclosures about DC&P and ICFR in their MD&A. First, the certifying officer's conclusions about the effectiveness of DC&P and ICFR at the financial year-end must be disclosed in the annual MD&A. It's important to note that if a material weakness relating to the design or operation of DC&P or ICFR is identified, the certifying officers cannot conclude that they are effective. Further, their assessment cannot be qualified by stating that the issuer's DC&P or ICFR is effective, subject to certain exceptions, unless the qualification pertains to one of the permitted scope limitations available in the instrument. Additionally, as there is substantial overlap between the definitions of DC&P and ICFR, it would be unlikely that an issuer's certifying officers would be able to conclude that DC&P is effective if ICFR is not effective. If a material weakness is identified, issuers must disclose a description of the material weakness, the impact of the material weakness on the issuer's financial reporting and its ICFR, and the issuer's plans or any actions already undertaken to remediate the material weakness. It should be noted that paragraph 5.2 is added to the issuer's annual or interim certificate to indicate that there are material weaknesses in design of ICFR, and paragraph 6b2 is added to the annual certificate to indicate that there are material weaknesses related to the operation of ICFR. As described in National Instrument 52109, an issuer is permitted to limit the scope of its design of DC&P or ICFR to exclude controls, policies, and procedures when an issuer has an interest in a proportionately consolidated entity, special purpose entity, or if it acquired a business not more than 365 days before the end of the financial period. An issuer that limits its design of DC&P or ICFR in these circumstances must disclose the limitation in the related MD&A, along with summary financial information about the related entity that has been included in the issuer's financial statements. The Companion Policy provides guidance on determining the appropriateness of applying a scope limitation. It should be noted that paragraph 5.3 is added to the issuer's annual or interim certificate to indicate that there is a limitation on the scope of design. Lastly, issuers must disclose any change in the issuer's ICFR that occurred during the period that is materially affected or is reasonably likely to materially affect the issuer's ICFR. It is important to note that a change in an issuer's ICFR that was made to remediate a material weakness would generally be considered a material change in an issuer's ICFR. Now moving back to the required certificates. There are circumstances where additional certificates are required to be filed by issuers. If a venture issuer voluntarily files an AIF for a financial year after it has filed its annual financial statements, annual MD&A, and annual certificates for the financial year, the issuer must file a certificate in Form 52109 F1 AIF. If a reporting issuer refiles its annual financial statements, MD&A, or AIF, it must also file new annual certificates for that financial year in Form 52109 F1R. Similarly, a refiled interim financial report, or MD&A, must be accompanied by new interim certificates for that interim period in Form 52109 F2R. While it may appear at first glance that both venture and non-venture issuers file the same certificate when there is a refiling, a closer look at the certificate reveals that the issuer must add the applicable paragraphs included in the originally filed certificate. It is also worth noting that the certificates represent that the signer has reviewed not just the voluntarily filed AIF or the refiled document, but all of the related annual or interim filings. Issuers have the option to file alternative prescribed certificates when they are party to certain events. An issuer may file annual or interim certificates in Form 52109 F1 IPO RTO or Form 52109 F2 IPO RTO respectively, as applicable, for the first financial period subsequent to an initial public offering prospectus filing, a reverse takeover or RTO if the issuer was the RTO acquiree and the RTO acquirer was not a reporting issuer immediately before the RTO, or upon becoming a non-venture issuer. These certificates do not include the representations regarding DC&P and ICFR included in the standard annual and interim certificates filed for non-venture issuers. Therefore, the certificates include a note to reader indicating this fact, similar to the venture issuer basic certificates. It is worth noting that for new reporting issuers, certificates are not required to be filed regarding annual or interim financial statements for financial periods that ended before the issuer became a reporting issuer, or annual or interim financial statements for an RTO acquirer for financial periods that ended before the completion of the RTO. There are also exemptions for issuers that comply with U.S. laws and for certain foreign issuers. Issuers that believe they may be exempt should review Part 8 of National Instrument 52109 to clarify their requirements. Certificate dates and when to file them. Certificates should always be dated the day they are filed, and generally certificates are required to be filed the same day that the related documents that they are certifying are filed. However, with regards to an issuer's annual filings, annual certificates should be filed on the later of the date on which an issuer files its AIF, if required, or the date that its annual financial statements and MD&A were filed. Certificates are filed separate from the documents they certify, and a separate certificate should be filed for each of the CEO and CFO. Staff have identified several consistent problems with certificates that have been filed by issuers. First, many issuers file the wrong form of certificate. Issuers should ensure that they are familiar with the different types of certificates that we've described in this presentation and ensure that the appropriate certificate is filed along with the issuer's related documents. Second, staff have identified instances where issuers have modified the language of a filed certificate. For example, we often see venture issuers remove wording regarding the annual information form from the annual certification, likely because they don't file an AIF. Nevertheless, altering the wording of a certificate is not permitted, and issuers must file certificates in the prescribed form. Staff may require refiling of certificates if we identify that this has occurred. Staff have also frequently found that due to discrepancies in dating, certificates do not adequately certify the related documents. For example, a certificate dated and filed prior to filing the financial statements, MD&A, and AIF will not certify those documents. Certificates must be filed on or after the date that the related documents that are being certified are filed, and certificates must be dated the day they are filed. If staff identify discrepancies in dating, an issuer will be asked to refile the certificates. Lastly, staff have seen instances where an issuer has failed to conclude on the effectiveness of ICFR and DC&P in their annual MD&A, even though they filed a certificate that indicated that the conclusion was provided. Conversely, staff have identified circumstances where issuers have disclosed in the MD&A that the CEO and CFO have certified the design of ICFR and DC&P, but the certificates that were filed did not address design of ICFR and DC&P. To avoid these issues, the CEO and CFO should ensure that the statements in the certificates are correct before signing and filing the certificate, and ensure that declarations made in the MD&A regarding certificates are accurate. Staff may question whether the design of DC&P is effective if these issues are identified. This concludes our overview of certification of disclosure, which forms part of the Continuous Disclosure 101 series. Other videos in this series can be found on our website. If you have any questions, please do not hesitate to reach out to the contacts listed on that page. Thank you for taking the time to watch.